Good morning, everybody, and thank you for joining episode 30 of our Saved You a Seat webinars. I am filling in briefly for Leslie Wyatt this morning. You may know that she typically handles the introductions. She will be joining us a little bit later. Per usual, today's webinar will be recorded and made available on our blog after the fact in case you aren't able to stay for the entire live portion of the webinar. And today we will be covering a review of the new ALTA policy forms. We have three guests with us today who have graciously agreed to join us and speak on this topic. We have Steve Gottheim, General Counsel at the American Land Title Association. We have Jennifer Wootton, Vice President and Senior Staff Underwriting Counsel at the Fidelity National Financial family of companies and an ALTA Forms Committee member. And we also have Lia Albizo, Vice President, Senior Staff Underwriting Counsel at Chicago Title, and also an ALTA Forms Committee member. If you have any questions during today's webinar, feel free to drop them in the question box. We will do our best to answer them during the webinar. And I will go ahead and pass it over to Steve, Jennifer, and Lia and let them show you more about the ALTA policy forms.
Thank you, Ellen, and thank you all for joining us today with SoftPro's Saved You a Seat series, and thank you to SoftPro for hosting us. So today we're going to kind of do a really big overview kind of the new policy forms. We're going to walk you through basically the process that the association and in particular our forms committee goes through as we develop these new forms. We're going to kind of talk to you about kind of the background of who makes up the forms committee and why that's important. And then we're really going to dive deep into some of these new changes when it comes to the new covered risks, exclusions, conditions. The goal of today's session is not to make you an expert on these new policy forms. Jennifer and Lia are the experts, and they are prepared to kind of answer any questions you might have. But the goal here is really give you a good overview, hopefully make you more familiar with some of the terms and some of the new ideas in these forms as you start to get more and more education through your underwriters, and also start to see some of those underwriting guidelines coming out over the next year as we get these in place. So with that, Jennifer, can we go to the next slide? So here's our basic overview for today. We're going to start off with the process of developing new forms and kind of what our ALTA Forms Committee does and how it works, and the thoughtfulness that goes into all the new phrases and terms and conditions and covered risks that you're going to see in the documents. We're then going to kind of walk through what's changed in these policies. So we're going to kind of go through the new loan and owners policies and really kind of give you a couple of the biggest highlights of what's changed in those forms. We'll talk to you about kind of some of the other endorsements and other products that have been updated as well, the homeowners policy, the short form, and the like. And then we'll hopefully have some time at the end for questions, so that you can kind of get a little bit deeper into kind of where your next level of education needs to go. So the forms adoption process is really a very ongoing process. You've got a good flow chart of what we do here on the screen. There's a couple of things that I want to really kind of highlight here as we work through this. So you see here in the first box, the process is ongoing, begins with an idea. For this round of forms that came out in 2021, that first process step, that first question, that first decision to say yes, it's time to update the ALTA forms, started in 2015. And since there, so about 6 years of time, we've gone through this entire process of the ALTA Forms Committee, in which Jennifer and Lia are on, discussing these issues, talking about some of the court cases, talking about some of the requests from customer groups that come up, trying to draft some new language. It goes through a number of public comment review periods, including a number of times where the committee will meet with some of our largest customer groups, whether it's Fannie Mae and Freddie Mac, whether it's representatives of the banking industry or of other large commercial real estate providers. And all of that then gets to our ALTA Board of Governors, which has the final approval to say yay or nay, let's publish this for real. And when we publish that, the new forms that happened earlier this year, that opens up yet another public comment period in which, again, more of the industry continues to provide comments, finds more typos, finds more of those issues that we need to consider, and then we post them effectively and start the industry implementation process, which is where we are now. So if we move to the next slide, we'll talk a little bit about who makes up our ALTA Forms Committee, because this is the group that does the heavy lifting when it comes to developing these new forms. And I should say again, this process started in 2015, started a 6-year process to get to where we are now. The last time these forms were updated was 2006. Those are the policy forms that you are all using today. Before that, 1992. So these are not documents that we tinker with every few years and kind of come up with another new clause. Oh, that covered risk really bit us bad. In this case, let's rewrite it now. It really does take a long time to go from baseline policy forms in our mind, and so we really want to make sure we're doing it right, and that's where these experts come in. So you see on the staff there's about 6 individuals, members of the committee over the last few years, but really 20 insurers are represented. This is a committee that's made up of title insurers from across the country, across the size and scope, from both larger companies like the Fidelity brands that both that Jennifer and Lia work for, to some of our smaller underwriters across the country, and some of our single state underwriters as well. Again, we get a lot of feedback from industry groups and industry partners. Both Fannie Mae and Freddie Mac is our 2 largest customers in our industry, but also folks that represent some of the sides of the commercial real estate family world, from both the American College of Mortgage Attorneys and the American College of Real Estate Lawyers. So again, we attempt to make sure that as we go through this 5-6-year process, that we are hearing all of the viewpoints possible to come into writing a final product. So if we move to the next slide, we'll talk about, why did we decide to change the policies now? I guess this is not something we do lightly. It's not something that we do every year. So what drove us to go and say, it's finally time to take those policies written in 2006 and update them for today? Well, first and foremost, it's the world has changed, especially the laws have changed across the country. 2006, we were before the financial crisis. We had not had Dodd-Frank. We did not even know about a thing called the CFPB. We hadn't had TRID and all of those types of things. Real estate wire fraud was not a major issue. Remote online notarization wasn't a thing. Just all of those laws were really passed in the last few years. So it was a number of new precedents that came into effect that really said that the legal landscape that we were working under as an industry has changed significantly since 2006. There's also, as we'll say and see on the next slides, a lot of court cases that drive into this. And if we can, the next slide. So just a handful of court of areas where the courts have gone into interpreting our policy form and really understanding, helping us really realize that maybe the risks that we were taking on are actually a little bit different than we thought they were previously to this. For those of you that are work in areas that have a large amount of Native American land, the McGirt decision was a major decision that came out of the Supreme Court a few years ago that really changed people's understanding of how do you dissolve a tribe, and if you don't do it correctly, does that still mean that land, even if it's been sold a number of times, is actually part of a tribal reservation? A lot of focus in the last year around the topic of discriminatory covenants. You see a lot of new pieces of legislation that have popped up. We for years have had a disclaimer at the top of Schedule A of the schedules of our policies, disclaiming those discriminatory covenants, but the landscape around those has been changing as well. And as we go through the rest of the new covered risks and new exclusions and conditions, you'll find again areas where court cases and the way courts have interpreted our forms has really driven our drafters to realize that we needed to be more precise in our language. So we move to the next slide. I think it's just probably a little bit more on the McGirt case. Again, if anybody really wants to know more about that case, feel free to ask a question during the Q&A period. We'll make Leslie answer it instead of making Jennifer or myself answer it, or Lia. But I think now we'll move on to kind of walking through. Jennifer, can you move to the next slide?
There we go.
So we're going to move on to the covered risks, and I'm going to turn it over to Jennifer and Lia.
Okay, thanks, Steve. So covered risk, just a little preface this. We have a lot of slides to get through, so there are some that we may move a little quicker than others, but hopefully we'll have some time at the end and go through some questions. So we'll start out with covered risk 2. Both the owners and the loan policies had some updates to the examples of title defects that can cause a covered loss, including a failure to perform the acts necessary to create a document by electronic means. Note that we've added the reference to remote online notarization, and then also the example of a repudiation of an electronic signature. Covered risk 2C also adds a boundary line overlap as an item that's covered under that covered risk. And here is a screenshot of the policy language itself. There are several of these throughout the slide deck, so we'll probably move relatively quickly through these since you can take a look at the forms that are posted on the ALTA website. Covered risks 5, 6, and 7 in both the owners and the loan. These are the government action covered risks. The language was updated to cover loss to the extent of the violation, enforcement, or exercise described in an enforcement notice. Enforcement notice is a new defined term. And what we're trying to address here, if you recall from the 06 policies, these covered risks referred to coverage for loss resulting from these certain government actions if a notice was recorded. Well, what kind of notice? That's the question we were trying to address with the new defined term enforcement notice. And we'll see on the next slide, here's the definition of enforcement notice. It's a document recorded in the public records that describes any part of the land and is issued by a governmental agency that identifies a violation or enforcement of a law, ordinance, permit, or governmental regulation issued by a holder of the power of eminent domain or governmental agency that identifies the exercise of a governmental power or asserts a right to enforce a PACA PASA trust. And I like to give an example here. I think it helps understand really what we're going for. So say, for example, you find in the chain of title from 1980 a mechanics lien form that's for the cost to remove an underground storage tank. Well, obviously from 1980, that's no longer valid as a lien, but if you happen to be an environmental consultant, you might look at that form and think that this could potentially indicate there's contamination in the ground, because what if that underground storage tank was leaking whatever it was holding before it was removed? Well, that's not the kind of notice we're talking about for purposes of 5, 6, and 7. So that's why we put in the new defined term enforcement notice, and we've specified the exact ways that this notice would trigger the coverage under these covered risks. Obviously, our 1980 mechanics lien isn't going to fall into any of these categories, so consequently, it's not considered an enforcement notice. Our new covered risk 8, if you recall really quickly to back up, in the 06 policies, covered risks 7 and 8 were combined into covered risk 7 in the 21 policy form, so that's why we have a brand new covered risk 8, which relates to PACA PASA trusts. If you aren't familiar with PACA or PASA, it's kind of spelled out here for you in the third bullet point: Perishable Agricultural Commodities Act and the Packers and Stockyards Act. This covered risk also utilizes that new defined term enforcement notice. Here's a picture of the covered risk itself: enforcement of PACA PASA trust, but only to the extent of the enforcement described in an enforcement notice. And there's the definition of PACA PASA trust. I will note that we have the little catch-all at the end there, or a similar state or federal law. On the Forms Committee, we had someone who actually called to our attention the fact that Texas has a milk statute, which creates the same types of risks as these federal statutes that none of us really knew about. I think unless you're in the agricultural industry, you're not really familiar with these state level laws. So, we added that kind of catch-all there for those that we're not aware of. Covered risk 9 for the loan policy. That's examples of matters that can impair the insured mortgage. Again, these are the same examples that we talked about in covered risk 2. We are adding the notation about remote online notarization and repudiation of electronic signature. The 06 policy covered risk 10 didn't call out the components of indebtedness that were covered. the new policy does, and these are the items that are now included. Covered risk 13 in the loan policy and 9 in the owner's policy. This is the creditor's rights coverage that was tweaked slightly. You'll notice that we've now include loss resulting from a court order providing an alternative remedy in both sections. Previously, it was only mentioned in 13A of the loan policy. We've also updated the section to ensure against loss from the prior transfer being rendered voidable under the Uniform Voidable Transactions Act, which actually replaced the 1984 Uniform Fraudulent Transfer Act in 2014. The old act defined a fraudulent transfer, so the 06 policy could refer to that, but fraud isn't actually required for a transfer to be considered a fraudulent transfer, so the new act doesn't include a definition for voidable or fraudulent transfer. So now we specifically refer to a voidable transfer under the Uniform Voidable Transactions Act. Moving on to the exclusions from coverage. We have 2 new exclusions, which we'll talk about in a moment, but the other changes to the exclusions are basically updating and making them consistent with revised language in the corresponding covered risks and the conditions. So for exclusion 1, we've added forfeiture, regulatory, and national security power to the language about police power. Exclusion 3E, if you recall, it referred to loss or damage that would not have been sustained if the insured claimant had paid value for titles. So the question mark was, well, what does that mean specifically? So we've updated the language to explain that it's consideration sufficient to qualify as a bona fide purchaser or encumbrancer under applicable recording laws. The creditor's rights exclusion now has a clarification that loss resulting from avoidable preference is excluded if not given as a contemporaneous exchange for new value. And again, it adds the reference to avoidable transfer under the Uniform Voidable Transactions Act, which we just discussed. This says the Uniform Voidable Transactions Act has been adopted in at least 19 states. I think we're up to 20 now, but that number I think is climbing, which is why we went ahead and built that into the policy. And this slide is giving you the screenshot of the policy language. Exclusion 7 in the loan policy, 5 in the owners. This is the PACA trust exclusion. Remember, we have the covered risk 8 if there is an enforcement notice of record disclosing the existence of this risk. If there is no recorded enforcement notice, it's excluded. Again, here's an image of the exclusion language in both policies and the definition of PACA trust. The second new exclusion, 7 in the owner's policy, 9 in the loan policy, loss caused by a discrepancy in the quantity of the area, square footage, or acreage of the land, or of any improvement to the land. And you're probably used to seeing this as an exception in the policy or possibly a note, because if you have a long meets and bounds legal description and the surveyor that developed that description includes a statement to the effect that there's X amount of acres included in this legal description, that's not a calculation that we've intended to ensure, so it's typically shown as an exception. So we've just built that into the form as an exclusion. Okay, moving on to the schedules. As you may have noticed on the schedules above the word Schedule A, there's now optional transaction identification data, which has several categories of information designed just to be helpful to our customers, lenders in particular, in order to communicate kind of post-policy issuance. It helps them identify certain data points. And here's the image of it while we're talking about it. So you will see this is, as I mentioned, it's appearing above Schedule A because it's not insured information. We're providing this as a convenience and a reference to our customers, but as this shows here that we're assuming no liability. That's set out in the conditions as well. This is entirely bracketed, so you may see some but not all of these items appearing on your policy form. Obviously, in many cases, you won't have both an issuing agent and an issuing office. You'll have either or. Schedule B now has this disclaimer language referring to discriminatory covenants. This is a pretty hot topic nowadays, as Steve mentioned in the intro. We on the Forms Committee had been working on building in this language, which again was typically included as an exception on Schedule B when there was a set of CC&Rs, say for example, that had some that we did want to take exception to and some that were obviously because of the nature of the restriction based on race or sex or sexual orientation, something along those lines were illegal and unenforceable. We would have taken exception to them and made these types of statements that they're not being republished or recirculated. For convenience, we've now built this in to the form so that no one inadvertently leaves this type of language out. The policies also revised the lead-in sentences. This is on Schedule B as well to clarify that we're not insuring against loss or damage resulting from the terms and conditions of any lease or easement identified in Schedule A. And again, this is language that you would typically show as an exception if there is a lease or easement on Schedule A. Typically because, you know, it's exclusion 3A. These are things that the insured, by virtue of asking that they be an insured interest, they have created, suffered, assumed, or agreed to. Now we're just being explicit by adding this language on Schedule B and not having to add a specific exception. And we'll take a look at the Schedule Bs here for convenience. As you notice, the color coding, the owners is green, the lenders is this kind of yellow gold. And with that, we're moving to the conditions, and I will turn it over to Lia.
Thanks, Jennifer. So we have a couple of new definitions and revisions to definitions that I'll go over. One is the term affiliate, discriminatory covenant, enforcement notice, PACA, PSA, trust, and state. And there was also revisions to the terms insured and public records. The affiliate now is defined as a wholly owned, that is wholly owned by the insured, that wholly or that wholly owns the insured, or that the entity and the insured are both wholly owned by the same person or entity. I want to note that an affiliate will be considered insured when the name insured conveys title to the affiliate by deed or other instrument transfer. The next new definition that we're seeing is the consumer protection law. It replaces the consumer protection laws and truth in lending that were included in the 2006 loan policy. We're going to move on to discriminatory covenant. I'm not going to read it to you. Jennifer mentioned that it was, you see it in the schedule, so I'm not going to read it here for you, but that's the new definition. Going on to the definition of insured, I think this is something to highlight. It doesn't alter the previous coverage. It just clarifies that insured is a person that holds title after acquiring the indebtedness, regardless of the means of acquisition. In the loan policy, it also I'm sorry, I lost my place. The thing that I want to highlight here is that in the 2006 policy, to be considered insured, and if you were an affiliate, you had to, there had to be no consideration. With the new definition, that is no longer necessary. You're considered an insured if you're an affiliate, if, like I gave the previous definitions, that you're wholly owned. I'm sorry about that. Excuse me, my phone is talking to me. I don't know why. My apologies. Going on to the next slide, Jennifer. We're talking about, okay, that's the definition of the insured. Like I said, what was noteworthy in that is that you no longer need to there has to be no consideration. Next slide. For the owner's policy, the definition is now you're considered insured if you're a trustee or beneficiary under the trust created by a written instrument. This is what we saw in the previous 2006 policy. There's two new categories now for insured under the owner's policy. One is a spouse who receives title because of a dissolution of marriage, transferred by a transfer effective on the date of the insured. The other one is another insured named in item 1 of Schedule A. And what that means, if you had 3 people on title originally and the third person conveyed it to the second or first or both, there's still 100% interest in the property, so they would obtain that in the coverage that was afforded to the person that is leaving title. Next slide, Jennifer. We have a definition for government, a new definition for government mortgage agency or instrumentality. The term does not impact coverage, but we want to note that but is used in the definition of insured or obligor. Please note that a government mortgage agency or instrumentality is not an obligor. The definition of the obligor is a person or entity that is or becomes a maker, borrower, or guarantee as to all or part of the indebtedness or other obligations secured by the insured mortgage. The next slide, please. Definition of public record. The new policy is a clarification. It distinguishes between those records that are public records for purpose of title insurance and not necessarily government records that fall outside the scope of how coverage is triggered. The new definition of state, it's just clarifying that the word state means the state or Commonwealth of the United States where the land is located, and also includes the District of Columbia, Puerto Rico, and the Virgin Islands. We're on to condition 8 of the owner's policy and the loan policy. This condition clarifies that the policy is a contract of indemnity and it's not an abstract of title, report, or legal opinion. I think we see this often in the underwriting world. We'll have people not understanding that the policy is actually a contract of indemnity. So it's nice now that it's right there and it kind of brings it to light. Among the other improvements is that it establishes a procedure for selecting when to determine the value for calculating loss. Now the insured can choose between alternative dates of determining the loss. It's no longer a condition of the insurance unsuccessful attempt to cure title. And next we're going to go over how you can calculate that loss. The fair market value is calculated as either the date the insured acquires title as a result of the foreclosure or deed in lieu, or the date the lien of the insured mortgage or any assignment set forth in item 4 of Schedule A is extinguished or rendered unenforceable by reason of a matter insured against by the policy. We also have a new subsection that provides alternatives to the insured claimant if the insured is unable to establish title, but attempts to it, but is unable to establish title. And that is the amount of insurance will be increased by 15%, and the insured may elect to either choose the date of settlement or the date of the actual notice to calculate the fair market value. Condition 8 for the owner's policy, this section has been revised to address the calculation of the fair market rate that we saw in the loan policy as well. However, if the title is voided at the time of the policy, there's also a mechanism for calculating the value, the fair market value. It's the amount of the insurance will be increased by 15%. It's an improvement from 10% in the 2006 policy. And again, here you see the insured claimant able to choose between the date of the settlement or the date of the claim. Condition 10 on the loan policy, we are seeing improved coverage here, and that there's a new subsection that states when the title is acquired by the insured as a result of foreclosure or deed in lieu of foreclosure, the amount credited against the indebtedness does not reduce the amount of insurance. So that's a significant change. On to conditions 15 of the loan policy and 16 of the owner's policy. This is the choice of law provision. This goes back to our new definition for state, where the state will be, provides the state law means where the land is located, and it extends to federal law. It will determine the validity of the claims against the title or enforcement of the policy. This provision was needed because of the McGirt case, and that we needed to establish what a true definition of what state was under the policy. On to condition 17 of the loan policy and 18 of the owner's policy. We have a new category called class action. It just simply states that claims or disputes must be brought by an individual capacity and not by a class action. There is changes to the arbitration section, but they essentially remain this. They've been revised, but essentially the meat of the provisions remain the same. And here too, we have to have claims and disputes must be brought by an individual and not by a class action.
So here we just have kind of a list of some of the other policies and forms that have also been updated that you can also find if you don't already have them on the ALTA website. The commitment, the short form residential loan policy, the homeowners, expanded coverage residential loan policy, both the assessments priority and the current assessments version, and the short forms of those policies as well. And we have updated endorsements. The majority of these endorsements really just have conforming changes. They're using new defined terms. The state in particular appears in several. Now it's a capitalized S because it's a defined term in the new policies. Consumer protection law is one that shows up in some of the endorsements, and that's what triggered an update to those. And then we have a new endorsement, the 34.1, identified exception and identified risk. It's the coverage is very similar to the 34, which was not updated. It's really just a reformatted form to better, I think, describe what the identified risk is that we're intending to provide coverage for. And with that, I think we're ready for questions if there are any. And I don't know if we lost our host or if we are still.
I'm here. Can you hear me?
Now we can.
I am so sorry. I'm having all sorts of technical issues today. Guys, this was such great information. I know it's so pertinent. I was just at ALTA 1, and I know you did a session there, and I don't want to talk about anything that you guys talked about in the very beginning of the meeting that I may have missed, but I know everybody at ALTA 1 really liked the session, and we had a lot of questions. I know from our customer base, we have a ton of questions, and a lot of them are very much based on timeframes. And I know that you've touched on some of this, but I think it might be just important if I could just ask you again real quick that I know these went into effect in July, and technically, I mean, I'll use the word sunset, even though they're not technically sunsetted, but at the end of the year. But is there a time in the future, and this may be more of a Steve question, I don't know, where you foresee agents or underwriters not being able to use the 2016 commitment or the older forms? Or is it just going to be for a while now, you can use both if necessary, just make sure you're using the correct commitment with the correct policy?
Yeah, so the simple answer to this is at least for the short-term immediate future, the rest of 2021 and probably probably almost all of 2022, you're going to kind of have both products in your arsenal as we start to get the 2021 forms approved in various states. And part of that is, as I said at the beginning, we work very closely with Fannie Mae and Freddie Mac, at least for the residential side of things, to kind of make sure that these products were going to be things that they would adopt as part of their guidelines. And one of the things that they've told us is that when their guidelines are updated later this year, early next year, they're going to allow both forms, the 06 and the 2021, until December 31st, 2022. And so we do expect you all as agents to be using both products for at least a period of time between now and December 31, 22. As we get past December 31, then I think you're going to find that the majority of what you're doing is going to be on the newer forms, and it's only going to be probably it's going to start to be a smaller subset of deals, whether it's in the commercial space or in states where they have not had the 21 forms adopted and approved yet, in which you might still use the 06s. Because we know there are a number of states that from the 06 timeframe took a little bit longer to get the new forms approved. And so, you could expect to see some of that delay impact the way you do business as well.
So another thing that you mentioned that I just want to reiterate, and I know you guys talked about a lot of this stuff, but there's some questions that I know we get repeatedly. One is there's a difference within SoftPro, just so everybody understands. We have the ALTA folder and all the ALTA forms, and we always update them every single time ALTA makes changes. But then again, we also have all the underwriter specific folders. And to Steve's point, what he just mentioned is the reason why you have this time to adapt and this time to kind of run them simultaneously is because in a lot of states, underwriters have to file those forms and get acceptance of those forms by the state, whether it be the Department of Insurance or land title or whatever the entity is. They need some time to get those approved. And so just make sure as a user that you know what form you're using and what form is expected to be used. And what I mean by that is just because we have what we call the canned ALTA forms already in there and ready to go, it doesn't mean that's what your underwriter wants you using. So just make sure to talk to your underwriter, whether it's your agency rep, doesn't matter what underwriter you're writing for, they're all going to have specific forms for specific states that they want used. And so just make sure that you are using the ones that they are currently set up to accept. You don't want to go ahead and start using the new forms and you're in a state where they've just filed and they haven't gotten the results back. So just make sure that you know what forms you're using, and then also make sure that if you're issuing a 2016 commitment, that you're using the 2006 policy and you're using the correct endorsements as well. So just make sure they all match, you're using what you need, and you're using what your underwriter is requiring. If you don't know, then just reach out. I promise you they'll be happy to let you know. At our end, we are in the process of working with all the different underwriters for every state to make sure that we get them in there as quickly as they get approved. And for some of them, it'll take longer just because of their processes, and due diligence is a little more in depth than others. So just kind of bear with us. And of course, if you have any questions, just either email us. You can email me at compliance, or you can also just call support or email support, and we can let you know where that particular package is at. Steve, and actually this could go to anybody, but we did get a question that said, so there is a new short form commitment ? Can you talk about that? Is there a new short form commitment or no?
I will defer over to Jennifer on this. I know that there's work being done to kind of make sure that all of the kind of most commonly used products are all ready to go in the next few months, and so the the Forms Committee has been working feverishly, and I know we had a slide, I think, that showed some of the other products that the committee's already finished, and some of the ones that are on the deck, like the short form products.
Yeah, we did. Let's see, we go back before the endorsements and it lists the short form commitment.
Okay, so yeah, so it looks like there is a new short form commitment, so that's good to know. You guys were so thorough. You guys did such a good job. I know it's hard to sometimes present this kind of information. I feel for you as a fellow presenter. Sometimes when you have to put a lot of words and verbiage and legal stuff up, it's not as interesting to talk about, but this was super interesting. I think that it was obviously pertains to everybody on this call. We had a lot of people register, and thankful that we were going to highlight this and talk about this. So I don't have any further questions. I think we answered everything. So I just want to thank you guys again for this. We really appreciate it. You explained it so much better than I could have. I definitely learned some stuff myself and took some notes. That's actually what I was doing when you guys were finished waiting for me to unmute. I was taking some notes. Steve, I may reach out to you with a couple questions that I had, but I think I'm going to just go through this deck again. And before I do, and see if there's anything I can figure out on my own. So with that, I just want to thank you guys again. Reminder to everybody on the call that we will send a recap and a blog post on this. And in that, we will put a link to the recording so that you can either view it later or share with your coworkers or use as a training internally, whatever you need to do. If you have any follow-up questions or comments, please feel free to reach out to myself or SoftPro support at any times. And again, to all of our speakers, thank you so much for your time. We really appreciate it. And I hope everybody has a great day and a great rest of your week.